This report has been developed following the participation of the judges in the hearing held in the Nieuwekerk, The Hague, Netherlands from 10 to 13 November 2015. During the 4 days of hearing, the judges heard oral submissions of the prosecutors as well as testimony and responses to questions by more than 20 witnesses, some of whom testified with their identity protected under pseudonyms and or behind screens. And they received several hundred pages of documents tendered as evidence. The prosecution presented its case as 9 crimes against humanity: 1, murder; 2, enslavement; 3, imprisonment; 4, torture; 5, sexual violence; 6, persecution; 7, enforced disappearance; 8, hate propaganda; 9, complicity of other states. Since the hearings, this wealth of evidence and supporting material has been further considered, providing the basis for this report. It is intended to amplify and provide reasoned justification for the judge's concluding statement delivered in the final session of the hearings on 13 November 2015. This report begins by addressing the overarching question of responsibility for the mass murders and other crimes, and then goes on to focus on the counts presented by the prosecution and in an amicus curiae brief submitted to the tribunal, concluding with a series of findings and recommendations. It was regrettable that the state of Indonesia did not accept the invitation to participate in the hearings, nor to make submissions to the tribunal, and neither did the governments of the United States and the United Kingdom and Australia, which were also invited. However, the judges welcomed the willingness of individual members of Komnas HAM and Komnas Perempuan to brief the tribunal. It should also be noted that some significant, though partial, steps towards addressing these issues have been taken in Indonesia since the tribunal was held, as the report outlines in an appendix. Acknowledgements. We wish to acknowledge in the first place the fundamental contribution of those eyewitnesses who had the courage to come forward to testify on facts that have touched their lives profoundly and forever. They are the most qualified representatives of the victims, whose numbers will never be known and whose suffering could never be described in full. We also recognize the contribution of many others, victims and witnesses, who by testifying in recent years, sometimes at personal risk, to national Indonesian human rights institutions such as the Komnas HAM and Komnas Perempuan, or in print or public forum, have also helped to throw light on the obscurity of the past. We thank too the Indonesian scholars, lawyers, and activists who participated in the IPT tribunal in November 2015. Legal framework. The role of the IPT and its panel of judges was clarified in the public statement issued in October 2015 before the hearings as follows. As the People's Tribunal, the tribunal derives its moral authority from the voices of victims and of national and international civil societies. The tribunal will have the format of a formal human rights court, but it is not a criminal court. It has the power of prosecution, but no power of enforcement. The essential character of the tribunal would be that of a tribunal of inquiry. Individual members of the tribunal have extensive knowledge of international and human rights law and of this period of Indonesian history. The judges of the tribunal will examine the evidence presented by the prosecution, develop an accurate historical and scientific record, and applying principles of international customary law, public international law, and Indonesian law to the facts as found, deliver a reasoned judgment. They will seek to establish without fear or favor the truth about these historic events in the hope that this will contribute to justice, peace, and reconciliation. In their opening statement read before the start of evidence, the judges said, "There is no doubt that the events of 1965 in Indonesia remain extremely important for Indonesia and for the world. We believe that the most notable and reliable account of the exact causes of what happened in 1965 and thereafter must be identified, and that this account is necessary if real, lasting, and just peace that includes reconciliation and reparation is to be achieved in Indonesia." Crimes against humanity. Crimes against humanity stand as a necessary ingredient and pillar of customary international law. They were tried for the first time in the military tribunals in Nuremberg and Tokyo. The existence of these crimes was later codified in the International Universal Declaration of Human Rights on 10 December 1948 and the Nuremberg Principles by the United Nations General Assembly in 1950. They were also recognized and accepted as part of Indonesian domestic law, as we mentioned below. We start with customary international law. As correctly pointed out by the prosecution, crimes against humanity in customary international law are fundamentally A, inhumane acts that are crimes in most national criminal law systems, B, committed as part of a widespread or systematic attack against civilians. The prosecution submitted that the inhuman acts are crimes against humanity in international law. It also urged that because the prohibition of crimes against humanity is a customary international law, jus cogens norm, derogation from these norms is not permitted under any circumstances. Customary international law, therefore, obliges these states to prosecute those responsible for the commission of these crimes or to extradite them to states committed to pursue prosecution of these people. Two matters must be emphasized. For crimes against humanity in customary international law to be proven, there must be a widespread or systematic attack against civilians. The attack need not be against the entire civilian population, but against part of it. Here, as will be shown, the widespread systematic attack targeted the substantial civilian population constituted by the Partai Komunis Indonesia, the PKI, the Communist Party of Indonesia, all its affiliate organizations, its leaders, members, and supporters, and their families, as well as those alleged to have been sympathetic to its aims. While initially the object of such instructions might appear to be limited to the small number of alleged leaders of the 30 September movement, it was always so, and soon became clear that the target was much broader and applied to anyone who might be identified as belonging to or supporting or sympathizing with the PKI directly or indirectly. Furthermore, some of the orders explicitly authorized army commanders to take action outside the law. Many other people also suffered who did not regard themselves as having any connection or even sympathy with the PKI. As time went on, the target broadened further to clear the ground for a thorough restructuring of society in which both the bureaucracy and the army were cleansed of left-leaning people in general, including many supporters of President Sukarno and progressive members of the Partai Nasional Indonesia, the PNI, who in many cases also suffered persecution. Secondly, it is not necessary for the attack to be both wide-ranging and systematic. A wide-ranging attack that is not systematic and a systematic attack that is not wide-ranging would each qualify separately as attacks which fall within the purview of crimes against humanity in customary international law. It must also be emphasized that to prove crimes against humanity, the acts which were part of the attack must be crimes in most countries considered as state practice. Indeed, the prosecution submits that all of the acts to be considered by the IPT qualify as crimes across the world, including in Indonesia, whose domestic law in relation to crimes against humanity is not much different. In 2000, the Indonesian People's Representative Assembly, the Majelis Permusyawaratan Rakyat, the MPR, adopted Law number 26 of 2000, establishing a human rights court in order to resolve gross violations of human rights defined by Article 7 of Law 2000 as gross violations of human rights, including both the crime of genocide and crimes against humanity. These follow closely those set out in Article 7 of the Rome Statute of 2000 governing the International Criminal Court. And Article 43 of Law number 26 of 2000 specifically provides that gross violations of human rights that occurred in the past to be heard and ruled on by an ad hoc human rights court. The article uses the word shall, and thus renders the formation of the court and the adjudication of these offenses peremptory. The definition of crimes against humanity is broadly similar in both customary international law and Indonesian law. The first difference is that the attack must be wide-ranging and systematic in customary international law, while it needs to be broad, systematic, and direct in Law number 26. Secondly, the Indonesian law sets out specific acts that must be part of an attack, while customary international law requires inhumane acts that are crimes in most countries. These differences are immaterial. Accordingly, this report sets out to show that A, there was an attack against civilians. All these acts were an integral part of a broad, widespread, systematic attack against the Partai Komunis Indonesia, the PKI Communist Party of Indonesia, its affiliate organizations, its leaders, members, supporters, and their families, as well as those alleged to have been sympathetic to his aims, as well as Sukarno supporters, and of course, more broadly, against people who had no connection to the PKI in what became a widespread purge, which included many supporters of President Sukarno and progressive members of the Partai Nasional Indonesia. B, the ingredients of these attacks relied upon by the prosecution, namely mass killings, imprisonment, enslavement, torture, enforced disappearance, sexual violence, and persecution through exile, which are crimes in most national jurisdictions and covered by Law number 26 of 2000, were indeed committed. The prosecution brief also argued strongly that the International Law Commission's articles on the responsibility of states for internationally wrongful acts, the ARSIWA, also imposes obligations and responsibility on the state of Indonesia for violations of crimes against humanity, and has referred to Article 42, which considers a serious breach to be constituted by a gross and systematic failure by the responsible state to fulfill its obligations. Findings and recommendations. 1. Findings. The state of Indonesia is responsible for and guilty of crimes against humanity consequent upon the commission and perpetration, particularly by the military of that state through its chain of command, of the inhumane acts detailed below. All these acts were an integral part of a broad, widespread, systematic attack against the Partai Komunis Indonesia, the PKI, the Communist Party of Indonesia, its affiliate organizations, its leaders, members, supporters, and their families, as well as those alleged to have been sympathetic to its aims, and more broadly, against many people having no connection at all with the PKI in what became a widespread purge, which included many supporters of President Sukarno and progressive members of the Partai Nasional Indonesia, the PNI. Each inhumane act was in addition a crime in Indonesia and in most civilized countries of the world. The attacks began with the false propaganda discussed here and consisted of the following inhumane actions that were part of the broader attack. The state of Indonesia also failed to prevent the perpetration of these inhumane acts or to punish those responsible for their commission. To the extent that some crimes were committed independently of the authorities by so-called spontaneous local action, this did not absolve the state from the obligation to prevent their occurrence and to punish those responsible. These acts are now summarized below. Killings. The most likely number of people killed is in the region of 400,000, although in view of official secrecy maintained to this day, the figure may be much higher or possibly lower. These brutal murders were sufficiently widespread to constitute the crimes against humanity of mass murder and or extermination, as well as violations of Indonesian domestic law, including the Indonesian Criminal Code, the KUHP, Article 138 and Article 140, and especially Law number 26 of 2000. These murders were also part of the widespread systematic attack on the PKI and all those deemed to be connected with it, as well as the attack against the supporters of President Sukarno and the members and supporters of the PNI. B. Imprisonment. Statistics are also lacking for the number of people detained in various forms of imprisonment, including forced labor and virtual enslavement. It was at least as many as 600,000 and probably much higher. The unjustified imprisonment was a crime in Indonesia and in most parts of the world at the relevant time, and was sufficiently widespread and systematic to also constitute a serious crime against humanity, as well as a violation of Law number 26 of 2000. These acts of imprisonment were also part of the widespread systematic attack on the PKI and all those deemed to have been connected with it and the other organizations mentioned. Enslavement. There is considerable evidence that many of the people who were detained were forced to work under conditions which amounted to the crimes against humanity of enslavement, as well as violation of the 1930 Convention concerning forced or compulsory labor. It was again a violation of Indonesian domestic law, especially Law number 26 of 2000. These acts of enslavement were also part of the widespread systematic attack on the PKI and all those deemed to be suspected, rather, to be connected with it, as well as the other supporters and organizations mentioned. Torture. Considerable evidence is available of the wide-scale use of torture having been inflicted upon prisoners and detainees in the period of the mass killings and imprisonment. Many instances are recorded in the reports of Komnas HAM and Komnas Perempuan, and other individual cases are described in witness statements and written evidence. There are explicit provisions against torture in Indonesian law, and there is an absolute ban on torture in international customary law. These acts of torture were part of the widespread systematic attack on the PKI and all those deemed or suspected to be connected with it, including the supporters of President Sukarno, as well as members of the PNI. Enforced disappearance. Considerable evidence is available of wide-scale enforced disappearances, sometimes as a prelude to imprisonment or execution, while in other cases, the victim's fate has never been determined. Evidence of these was provided in the Komnas Ham report and by witnesses and case studies presented to the tribunal. Enforced disappearance is prohibited by international customary law. These acts of enforced disappearance were part of the widespread systematic attack on the PKI, all those deemed to be connected with it. F. Sexual violence. Evidence of sexual violence recorded in the Komnas Perempuan report and submitted in oral and written form is compelling and conclusive. The detail of the tribunal are mutually corroborative and present a picture of widespread systematic acts of sexual violence aimed against women alleged to be associated with the PKI in any way. These acts included rape, sexual torture, sexual enslavement, and other forms of sexual violence. These acts were and are crimes in Indonesia, especially Law Number 26 of 2000, and also constitute crimes against humanity as part of the widespread systematic attack on the PKI and all those deemed to be connected with it. Exile. Those Indonesians whose passports were confiscated abroad were deprived of their full and unconditional rights of citizenship. The policy of involuntary or forcible exile, apart from being inhumane conduct, formed part of a widespread systematic state attack against a substantial and significant targeted sector of the civilian population and may well be a crime against humanity in the form of persecution. Propaganda. The official version of what happened to the prisoners at Lubang Buaya was totally false. The true facts were known to the military leadership under General Suharto from early on, but were deliberately distorted for propaganda purposes. The sustained propaganda campaign against those accused of being linked to the PKI helped to justify the extra-legal persecution, detention, and killing of alleged suspects, and to legitimize the sexual violence and all the inhumane conduct already described. Unchallenged for more than 3 decades, this propaganda also contributed not only to the denial of civil rights of survivors, but also to their continued persecution. Spreading false propaganda for the purpose of preparing the ground for violence is integral to the commission of that violence. The act of preparing for the crime cannot be said to be separate from the crime itself. This preparation paved the way and was the beginning and part of the overall broad attack. I now deal with complicity of other states. The United States of America, the United Kingdom, and Australia were all complicit to different degrees in the commission of these crimes against humanity. The US gave sufficient support to the Indonesian military, knowing well that they were embarked upon a program of mass killings and other criminal conduct for the charge of complicity in crimes against humanity to be justified. The clearest evidence of this was a supply of lists of names of PKI officials when there was a strong presumption that these would facilitate the arrest and or execution of those that were named. The UK and Australia conducted a sustained campaign repeating false propaganda from the Indonesian army, and they continued with this policy even after it had become abundantly clear that the killings and other crimes against humanity were taking place on a mass and indiscriminate basis. On balance, this justifies the charge of complicity in the above crimes against humanity. The governments of the countries referred to above were fully aware of what was taking place in Indonesia through their diplomatic reports, from contacts in the field and accounts in the Western media. Genocide. The facts brought before the tribunal by the prosecution include acts that fall within those enumerated in the Genocide Convention. These acts were committed against a significant and substantial section of the Indonesian nation or Indonesian national group as a protected group as enumerated in the Genocide Convention, and were committed with the specific intent to annihilate or destroy that section in whole or in part. This possibly also applies to crimes committed against the Chinese ethnic minority group. The state of Indonesia is bound by the provisions of the 1948 Genocide Convention under international customary law. Finally, I read the recommendations. This report calls upon the Indonesian government urgently and without qualification to A, apologize to all victims, survivors, and their families for the commission by the state of all the crimes against humanity and other crimes committed in Indonesia in relation to the 1965 events. B, investigate and prosecute all crimes against humanity. C, ensure appropriate compensation and reparation to victims and survivors. This report fully supports and urges all relevant authorities to heed and comply with 1, the call of Komnas Perempuan for a full investigation by the government of Indonesia and full compensation to the surviving victims of sexual violence as well as to their families. 2, the call of Komnas HAM that the Attorney General should act on the basis of his 2012 report to conduct investigations in what are deemed to have been grave violations of human rights that occurred during the events of 1965, 1966 and afterwards. 3, the call made by victims and other individuals as well as Indonesian human rights groups for the government and all sectors of Indonesian society to A, fight impunity, agreeing that impunity for past serious crimes against humanity poisons a society and breeds new violence. B, rehabilitate the victims and remove any still outstanding persecution by the authorities or restrictions on their full enjoyment of all human rights guaranteed under international and Indonesian law. And finally, C, establish the truth about what happened so future generations can learn from the past. Thank you very much.